So in today's video, I have something hot off the press. This is a news release from Region 7 of the EPA office, which is in Kansas City. And it's talking about a fine that's been levied on a Nebraska landlord. This is from July 26 of 2023. It says a residential leasing company in Hastings, Nebraska has agreed to pay $24,579 in civil penalties to the Environmental Protection Agency to resolve alleged violations of the Federal Toxic Subsistence Control Act, which basically is lead-based paint issues. According to the EPA, the leasing company, and I'm not going to give you the name, you can look it up if you want to, failed to notify the tenants of potential hazards of lead-based paint exposure at the company's properties. In addition to this article, I also watched a news report from KLKN, Channel 8 in Lincoln, and this particular enforcement action was brought on by a complaint that was filed. Now, it doesn't say any more about the details specifically of what the leasing company was cited for, and it doesn't say who made the complaint. But there are a couple of things from a broader view that I wanted to talk about in relation to this lead-based paint article. Number one is this was a complaint-based enforcement action. And good chance the tenant called in to the EPA and made a complaint. But there's also one other possibility that we need to start being aware of. What's starting to happen across the United States is a lot of your smaller municipalities, they don't have code enforcement departments, and they really don't have a way to deal with landlords that don't comply with code. It could be, and I'm not saying that this is the case, but it could be that the city of Hastings actually was the one who filed a complaint with the EPA and said, hey, can you help us out here? We've tried to deal with this particular leasing company in the past, and they're not keeping their properties up, their pre-78 properties, etc. You know the drill. And the thing I want you to be aware of is when an individual calls the EPA enforcement office, it doesn't have as much clout, if you will, or sense of urgency than if a municipality does. And I do think that the municipalities are going to start using the EPA in this fashion a lot more as we progress. And that's something as you as a housing provider need to be aware of, that the community that you're in, just because they don't have some kind of code enforcement department, they still have ways of making you, comply with the rules and regulations. One other thing that I want to chat about here is it doesn't specifically say what the leasing company was cited for, but this is a great reminder of your duties and obligations as a housing provider when it comes to lead-based paint. And anytime there is enforcement action regarding lead-based paint, it usually falls in one of two buckets. Number one, it's a lead-based paint disclosure issue, or it's an RRP issue. An RRP is renovation, repair, and paint rule. It's a rule that went into effect in 2010, and it governs how housing providers, things they have to do and the certifications that they have to use when doing maintenance on pre-78 homes. This went into effect in 2010. My gut tells me here, based on my experience the last 20 years with these type of articles, this was a lead-based paint disclosure issue. And either way, I just want to remind you of what your obligation is. For those of you that know me, for those of you that have taken my continuing education classes in the past, you know that I really make a big deal out of the lead-based paint issue. And this article and situation illustrates precisely what I'm talking about here. $24,579 was the fine that was agreed to, I'm assuming through some type of negotiation. And if not, it doesn't matter. If it was assessed, it doesn't. Either way, it doesn't matter. This landlord has to pay this. This is going to come out of this landlord or this leasing company's coffers. There's no insurance policy that's going to cover this. There's no insurance policy that's going to pay this. This is on this particular leasing company or landlord to pay it. That's the problem. These type of things are very punitive. The second part is you have to know how to comply with lead-based paint issues, whether it's the lead-based paint disclosure or the RRP ruled requirements. And so many landlords don't know. They just don't know, or they refuse to know. So I'm going to recap exactly what you need to do. Number one is those lead-based paint disclosures are required for any property that you own and rent out, or any property that you manage on behalf of an owner that was built prior to 1978. The lead-based paint disclosures must be filled out completely and accurately. There cannot be any misinformation on there, wrong information, and all the information that the form is asking for must be provided. If you omit something, then that you are subject to a notice of violation if that particular file is audited. And it's really important that the document is signed and dated by the landlord and the tenant. One of the issues that I do see when there are audits that are done, many landlords get nailed for a notice of violation because there are two tenants on the lease agreement, but only one tenant that signs the lead-based paint disclosure. So make sure that it's completely filled out accurately. Number two, you must provide that pamphlet that protect your family from lead in your home. That has to be given to the prospective tenant as well. And the other thing with that is please make sure that you know what the latest version of that pamphlet is. The EPA updates it very regularly, and you need to make sure that you're using the most up-to-date version. If you don't, then that's a notice of violation potentially. Number three, you have to provide, in addition to the pamphlet and the lead-based paint disclosure, any lead-based paint related documents. And so often when I talk to landlords and managers, they'll say, listen, I had test results, but it was a negative test result, so I didn't provide it. Well, then you're subject to a notice of violation. It's all related documents. So if you've had test results, whether they're positive or negative for lead, you have to provide that to every prospective tenant from here to perpetuity. 25 years from now, if you're still managing that property or you still own that property, you're going to have to give those same results to those tenants 25 years from now. Again, anything related to lead-based paint hazards, any documents, no matter what it is. Here in Omaha, we had the Superfund site in South Omaha where they were doing lead remediation in the yards. And there was a lot of documentation that was provided, test reports, etc. Even the letters from the EPA of notifications, that's all subject to disclosure to that prospective tenant. So you have to make sure that you have those in a file and you make them available. And trust me, sometimes, your stack of related documents can be a half inch or an inch thick, but that is what's required. And the burden is on you to prove that you provided them. And then lastly, which we're not going to talk about in this video, but if your home was built prior to 1978, any work that's done on that property, for the most part, there are a few minor exceptions, has to be done by EPA certified RRP contractors. And so either you have to be, as a landlord, an RRP certified contractor that oversees the work by non-RRP certified contractors, or you have to hire an RRP certified contractor. And one last thing regarding that is if you're a third-party property manager as of March 21st, 2022, you must have, if you are involved in any way with the maintenance of your portfolio that you manage, even if it's just simply taking the phone call from the tenant and relaying the maintenance request onto the owner, you must have on staff, meaning W-2, an RRP certified contractor. And if you're the only person in that management company, then you as the property manager must be RRP certified. I did a video on that, and I'll leave a link right up here to that video if you want to review that. Bottom line here is when it comes to lead issues, there's nothing in this industry, nothing, that terrifies me more than lead-based paint issues. So please make sure that you're in compliance, because an issue is only an issue when it's an issue, and then when it's an issue, and regarding lead-based paint, then it's a big issue, as you can see by the fine here that this particular leasing company was given by the EPA. That's all I got, everybody. I'll see you in the next video.